Hello, and welcome, seekers of knowledge, to another episode of Your Pocket DPO, a privacy podcast, with your host, Alexandra Stanford. If you're new to the show, this podcast is your one stop center for everything data protection related. I read privacy policies, break it down, and present it to you, have trivia questions that will leave you thinking, interview various privacy professionals about their opinions and contributions to the privacy and data protection field, and present all of the latest news, issues, and information in the privacy field. You guys are probably wondering where I disappeared to. First of all, let me apologize for being away so long. But I started a master's degree in August at Tilburg University in Law and Technology, and I have been busy studying for my classes and helping other students in my study group. I've been also researching for my thesis that I'm excited to be working on, and of course getting much needed rest and having some kind of social life. But I have been updating my social pages in the meantime, so if you want to know more privacy knowledge and stay up to date with the latest privacy news, visit my Instagram page at YourPocketDPO and my Twitter or X page at YourPocketDPO. Since I'm studying for my privacy exam, I think it is a good fit to bring you along for the ride. So, for the next few segments, I will be presenting topics on the basis of data protection in Europe. And as usual, we begin with some history. We begin in 1948 at the United Nations and the creation of the Universal Declaration of Human Rights, which is a non-binding instrument but has influenced the European human rights. Article 12 of the Declaration establishes the right to privacy. Article 12 states that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or acts. In 1976, the International Covenant on Civil and Political Rights proclaimed that no one may be subjected to arbitrary or unlawful interference with their privacy, home, or correspondence, nor to unlawful attacks on their honor and reputation. 169 parties must respect and ensure the exercise of individuals' civil rights, including privacy. In 2013, a bombshell dropped, which is known as the Snowden incident. Snowden exposed a collection of citizens' private communications, which provoked public outrage in the US and around the world. In response, the UN adopted two resolutions on privacy issues entitled The Right to Privacy in the Digital Age. These instruments are non-binding, but started debate on privacy in the new age of tech and surveillance. The UN strongly condemned mass surveillance and highlighted the impact such as surveillance can have on fundamental rights to privacy and freedom of expression and on the functioning of a vibrant and democratic society. These resolutions stated that the increasing capabilities of business enterprises to collect, process, and use personal data can pose a risk to the enjoyment of the right to privacy in the digital age. So, the public and private sector entities have a responsibility to respect human rights and call for companies to inform users about the collection, use, sharing, and retention of personal data and establish transparent processing policies. Notice, listeners, that the right to data protection is not a separate right under the UN framework, but is a part of the right to privacy. Now switching to the European perspective. Within the European region, there exists two data protection frameworks. One that is created by the Council of Europe and the other that is created by the European Union. Firstly, I will discuss the framework created by the Council of Europe. In the 1950s, the Council of Europe created the European Convention on Human Rights, the ECHR. Article 8 of this convention guarantees the right to respect for personal life, family, home, and correspondence, which includes personal data, which is not a separate right under this convention. The right to personal data forms a part of the rights protected under Article 8 of the ECHR, which guarantees the right to respect of private and family life, home and correspondence, and lays down the conditions under which restrictions of this right are permitted. Contracting parties, which are the countries that signed the convention, must respect the rights stipulated in the convention when exercising any activity or power including national security. Furthermore, the Court of Human Rights has not hesitated to affirm that surveillance activities constitute an interference with respect for private life. The court has clarified that Article 8 of the ECHR not only obligates states to refrain from any actions that might violate this convention right, but that they are in certain circumstances also under positive obligations to actively secure effective respect for private life and family life. The court has also ruled that personal data protection is an important part of the right to respect for private life under Article 8 of the ECHR, and has been guided by the principles of the Convention 108 in determining whether or not there has been an interference in this fundamental right. For persons seeking a judicial remedy and would like to access the court, the alleged violations must take place within the jurisdiction of one of the contracting parties. In the mid-1970s, the Committee of Ministers of the Council of Europe adopted various resolutions on personal data protection referring to Article 8 of the ECHR in response to the emergence of information technology in the 1960s. These recommendations concern the protection of the privacy of individuals vis-à-vis electronic data banks in the private sector and public sector. In 1981, the Convention for the Protection of Individuals with regard to the automatic processing of personal data, also known as Convention 108, was adopted. This was a legally binding international instrument that applied both to the public and private sectors. It outlawed the processing of sensitive data that reveals a person's race, politics, health, religion, sexual life, or public record without legal safeguards. Within the convention, we see several principles such as fair and lawful collection and processing of personal data, specified legitimate purposes for processing personal data, data being kept no longer than necessary, data quality, and the right to information and right to rectification. Also, restrictions can be placed on the rights laid down in the convention due to state security or defense. And finally, the convention poses restrictions on the free flow of personal data between its contracting parties and a third-party state where legal regulation does not meet equivalent protection. An interesting fact about this regulation is that it is not subject to judicial supervision of the Court of Human Rights, but has been taken into consideration in case law of the court within the context of Article 8 of the ECHR. In the late 1980s, the Committee of Ministers adopted several more non-legally binding recommendations that influenced the data protection law in Europe. The principles contained in the recommendations, such as the means for retaining data files and the need to implement clearer rules on the persons allowed access to those files, are further developed and are reflected in subsequent EU legislation, such as the Data Protection Directive. Most recent recommendations seek to address the challenges of the digital age, for instance, in relation to data processing in the context of employment. In 2001, the additional protocol to Convention 108 was adopted, and this instrument introduced provisions on trans-border data flows to third countries and on the mandatory establishment of national data protection supervisory authorities. In 2011, Convention 108 was updated and became the modernized Convention 108. It reaffirmed and stabilized important principles and provides new rights to individuals while simultaneously increasing the responsibilities of entities that process personal data, ensuring greater accountability. To counter the increased use of profiling in the online world, the convention also established the right of the individual not to be subjected to decisions solely based on automated processing without having their own views taken into consideration. Effective enforcement of data protection rules by independent supervisory authorities in the contracting parties is considered central to the convention's practical implementation. To this end, the modernized convention underlines the need for supervisory authorities to be vested with effective powers and functions and to enjoy genuine independence when fulfilling their mission. In this timeline, 2 years after the adoption of the modernized Convention 108, the Snowden incident occurred. Now for the framework created by the European Union. This begins with the Data Protection Directive in 1995, which harmonized national data protection laws to ensure a high level of protection and free flow of personal data among different member states. This is important because these member states were complying with the Convention 108 by themselves, and while everyone had their own way to follow the convention. But since they were part of the European Union internal market, free movement of goods, capital, services, and people within the internal market required free flow of data. The directive reflected the data protection principles already contained in national laws and in Convention 108, while often expanding on them. The directive established a detailed and comprehensive data protection system in the EU. However, since it was a directive, member states still transposed the directive differently through national laws, with diverse definitions, severity of sanctions, etc., led to some fragmentation. There were significant changes in information technology since the drafting of the directive in the mid-1990s. Taken together, these reasons prompted the reform of EU data protection legislation in 2016. This reform led to the adoption of the General Data Protection Regulation, also known as the GDPR, which preserved and developed the core principles and rights of the data subject provided in the Data Protection Directive. It introduced new obligations requiring organizations to implement data protection by design and by default, to appoint a data protection officer, DPO, in certain cases, to comply with a new right to data portability, and to comply with the principle of accountability. The GDPR thus provides a single set of data protection rules across the EU and creates consistent data protection rules throughout the EU, establishing an environment of legal certainty from which economic actors and individuals such as data subjects may benefit. Since the GDPR is directly applicable, member states are expected to update their existing national data protection laws to fully align with the regulation, also reflecting a margin of discretion for specific provisions in Recital 10 of the GDPR. Also in 2016, the Law Enforcement Directive was adopted that established a more comprehensive system of personal data protection in the context of law enforcement. It applied to activities of law enforcement such as prevention, investigation, detection, or prosecution of criminal offenses. The directive seeks to balance between individual rights and the legitimate objectives of security related processing. It closely follows the rules and principles enshrined in the GDPR and takes into account and tries to address serious emerging technological challenges that can have a particularly erroneous impact on individuals, such as the use of profiling techniques by law enforcement authorities. The processing of personal data in the police and criminal justice sector is now subject to supervision of independent supervisory authorities. In 2018, a data protection regulation for the processing of data by EU institutions repealed an older legislation which allowed the processing activities by the EU to align with the new data protection regime under the GDPR. This new data protection regime under the EU was made possible by the Charter of Fundamental Rights that not only guarantees the respect for private and family life under Article 7 of the Charter, but also establishes the right to the protection of personal data, which is under Article 8 of the Charter. The Charter explicitly raises the level of this protection to that of a fundamental right in the EU. The Charter therefore not only explicitly mentions a right to data protection under Article 8.1, but also refers to key data protection principles in Article 8.2 of the Charter. Finally, under Article 8.3 of the Charter, requires an independent authority to control the implementation of these principles. After the adoption of the Lisbon Treaty, the right to data protection is specifically provided for in Article 16 of the TFEU, under the part of the treaty dedicated to the general principles of the European Union. Article 16 also creates a new legal basis granting the EU the competence to legislate on data protection matters. Article 16 of the TFEU now provides an independent legal basis for a modern comprehensive approach to data protection which covers all matters of the EU competence, including police and judicial cooperation in criminal matters. Article 16 of the TFEU also affirms that compliance with data protection rules adopted pursuant to it must be subject to the control of an independent supervisory authority. Article 16 of the TFEU also serves as the legal basis for the adoption of the comprehensive reform of data protection rules in 2016, but under Article 52.1 of the EU Charter provides safeguards regarding potential limitations that may apply to the rights and principles guaranteed by the Charter. Limitations may only be imposed by law and must respect the essence of the guaranteed rights and freedoms. Furthermore, these limitations must meet the proportionality criterion. They must be necessary and generally meet objectives of general interest recognized by the EU or the need to protect the rights and freedoms of others. There is another instrument that is important in this timeline, which is the e-privacy directive, but I will address this in another episode because we are currently discussing it in class this week. I think I've given you an overview of the data protection timeline in Europe. Next episode, I will answer the question, when does the GDPR apply? As I near the end of my podcast, I have a trivia question for you. I am an immigrant and I believe that my personal data was mishandled by Frontex. the European Border and Coast Guard Agency that supports the EU member states and Schengen associated countries in the management of the EU's external borders and the fight against cross-border crime. Which legal instrument do you think applies to them? A. The General Data Protection Regulation. B. The Law Enforcement Directive. Or C. The Data Protection Regulation for the processing of data by EU institutions. Think about it, do some research, and let me know in the comments your opinions. Thank you again for sharing your time with me today, and wherever you are in the world, I bid you good day, good evening, and good night. Until next time, bye!